She can sit right in that last seat over there in the jury box, and I will call it back up when she has her story straight.
Thank you, Judge.
But if she's up here and she's lying to me, ma'am, I don't play that way.
Right.
So if you come up here lying to me and don't tell me the whole truth, because I can see exactly what's going on here. I'm not stupid. But if you come up here lying to me, you're going to go. It's really simple.
Thank you, Your Honor.
Court calls case People versus Julie Vampa Pachon. I mess it up every
I
time.
had that 5 times.
All right.
Assistant Public Defender on behalf of Miss Julie Valpachon.
That's right.
All right. Please take your.
Attorney Morgan Barroso on behalf of the people.
Please take your record.
Julie Valpachon.
Thank you, Judge. I have spoken to Ms. Barroso and to Ms. Valpachon about this matter. We are close to a resolution. The people have made a reasonable offer.
Go ahead.
Have made a reasonable offer. The issue, if there's an NDOP, it's going to be requiring something to be paid off that may have already been paid off. So I need to get a receipt from Ms. Valpachon before we're prepared to resolve it. Before we're prepared to resolve it. So I'm asking for a short, either 1, 2, or 3 week adjournment, whatever fits the court schedule best, to get that receipt and turn it over to Ms. Barroso to see if that will help to resolve the matter.
Okay, that's fine. Hey, but there a reason why she hasn't been going to community corrections?
I was sick. I was in the hospital.
She missed, she had a court date scheduled for February 14th. That was also.
No, I understand that, but she had missed to January 10th, she tested negative. January 19th, she missed. January 22nd, she missed. January 24th, she comes in, test positive for THC. And then she misses February 7th. And then misses February 9th. And according to this, was in the hospital on the 13th through the 15th.
Okay. So I understand what the court
Mr.
said.
Allen.
She missed several tests. It sounds like in late January into February.
And the only test that she then took for that period was positive.
So I know she was in the hospital, which is why the February 14th court date was adjourned.
Right, I have that one,
Right.
but she hasn't been testing.
Okay. She did indicate that she went to go test today. They did not drop her. They told her to wait till after court.
Yeah, because she hasn't been testing.
Fair.
And
I just found I had pneumonia. And I was sick. Like I just had it. Whatever.
did you read this violation report?
I did not, Judge.
Because I don't know what's going on with this individual, but the very first conversation, there's a call made to the phone, and it looks like some games are being played with community corrections.
Okay.
And she tests positive for marijuana, but then indicates she doesn't have a MMC. She doesn't have a medical marijuana card. And that she was at a party and had 2 marijuana laced cookies. So on. And they keep telephoning her, said she was unable to take the test on 119, having to pick up her kids. Then she reminded that they were open from 8 a.m. to 4:30 p.m., instructed to report to community correction on January 24th. She did, and that's when she tested positive. she hasn't given any on the February 15th, although the court has them. She didn't give any medical documentation to the two community corrections.
You didn't give it to the court. You must have given it to Ms. Gaines. Oh. Yes, my understanding is she was working with Ms. Gaines. I guess that must be how the court ultimately received.
Pardon?
You said that the court had not received the hospitalization.
I have it. I have the hospital. That's fine with me. It's the stuff before this that is very concerning because she does her first test, she's negative. Then she just doesn't seem to do testing as though she's not taking what the court says very serious.
I'll continue to go test.
And then she's talking about, then there's this whole issue with the phone back at the beginning of January about the appointment.
Obviously, I did not.
And then she's talking about having to pick up her kids, and that's fine, except they reminded her that they're open from 8 to 4.
Did I go to testing after that for, like, she told me I could go the next day. And I believe I went that day,
What day?
the day after that I was supposed to pick my kids up.
On the 24th. Right. That's the only test you've done.
Okay.
Do you have it in front of you? You want to see my copy?
Judge, I don't have it in my.
I don't, but
Thank you.
no, I have not been tested. That, like,
He wants to. That's on 110. When she reported to community corrections required the intake. Yes, with the marijuana laced cookies, it appears, Your Honor. Yeah, approach.
Yeah. So she had the marijuana cookies on which day?
It looks like in the report she said on 110.
That was after she was arrested.
I guess so, Judge.
But she just told me it was before she was arrested. So which one is it?
before. No,
She doesn't recall, Judge.
What?
She doesn't know the date. Obviously, Judge. I don't know when she was arrested. She believes it was
So
right.
tell me about the phone. Because see, I have a feeling you're playing games with me.
I don't know anything about no phone. I don't remember. I don't know nothing about no phone.
The judge says that the report we're not returning, we're not making phone calls, it's not the right phone number for you to reach you to do the testing.
Well, no, that beginning part of the report
Yes, sir.
where they tried to call and they said they were trying to return it to the owner and they said it was actually her on the phone.
You understand what Judge
Oh,
said?
yeah, when I lost my phone and,
That's what he's asking you about.
yeah. I had lost my phone and I was getting it back from the person.
That's what he's asking you
And
about.
they said that person said somebody called me or something like that. And
So Judge is asking you about the phone. When did you lose your phone? How did you get your phone back? He wants an explanation for when.
I don't remember the exact dates, but whatever it is, I accept full responsibility.
No,
Whatever.
Oh, I don't know you want to do that because that'll make my job a whole
remember
lot easier.
when I lost it.
Well, how'd you get it back? That's what he wants to know.
I called my phone and I met up with the girl to give my phone back
Okay, where?
at the gas station.
Okay, how'd she get it?
I left it there.
At the gas station. What gas station? He wants them details.
The Citgo gas station right here outside of Hogback, whatever it's called right here.
Okay. So my understanding from what she's telling me, Judge, is that she left her phone at the gas station, the Citgo.
This was before the delayed marijuana cookies.
That's my.
Oh, okay.
Correct?
This is after the cookies. I ate the cookies before I was arrested. A couple of days before that, I got arrested on the 31st.
Ma'am. You have laced cookies. Take a test, it shows up negative. Then 14 days later, we probably would have known before then, But 14 days later, then you take a test and that's when it shows up in your system.
Judge is saying that it should have showed up immediately. That's what he's suggesting.
Okay,
So he wants to know how's that possible?
I don't know.
Was there another slip? That's what he wants to know.
No,
Were you around someone who could have been?
Okay, look, here's the thing. Mr. Feaster, I realize you may be at a slight disadvantage because you don't have the report in front of you.
Judge.
I'm gonna give you my copy of the report. She can sit right in that last seat over there in the jury box. And I will call it back up when she has her story straight.
Thank you, Judge.
But if she's up here and she's lying to me, ma'am, I don't play that way.
Right.
So if you come up here lying to me and don't tell me the whole truth, because I can see exactly what's going on here. I'm not stupid. But if you come up here lying to me, you're gonna go. It's really simple.
Have a seat right there. He said.
Have a seat right, that last seat up there.
May I borrow that again, Judge?
Two o'clock block already? No, I'm gonna take a break. Benson, why'd you go like, what do you have?
I was told to be here by Queen Anne.
Okay, then just sit there. The queen hasn't released you.
I have two to substitute in for Reggie.
You got someplace to go?
Yes.
No, he doesn't. I'm gonna grant the motions. So if you wanna go, go.
And can I leave?
Court's gonna stand in brief recess about just 5 or 10 minutes.
All rise.
Court recalls the case of the, Mr. Feaster here. People versus Julie Vampachung, I think.
Ready again, Judge Torshell Feaster, Assistant Public Defender on behalf of Ms. Julie Von Pachan. And to my right at the podium, please state your name again for the record.
Julie Vampachan.
Thank you, Jeff, for giving us the opportunity to pass this matter so I could get a copy of the report and review it. I did talk to Ms. Barroso about this report. Our office did not receive a copy of it, so I did not have it. We didn't have it, so I apologize for that, Judge.
No, it's okay.
In going through the report with Ms. Wapachan, I do have some corrections, clarifications to the information I was providing previously, Judge. She does.
Oh, so now she's gonna tell the truth.
Yes, Judge. Yes, Judge.
Go ahead.
Thank you, Judge. She did lose her phone at the Sunoco gas station at 3891 Platte. About 1/7.
Is the Sunoco,
The Sunoco.
not the Sitco?
Sunoco, right?
Whatever the one's right outside of here.
Sunoco, I believe, is what she believes it was, Judge. She says that that phone was recovered prior to her first meeting with Community Corrections when she got her phone back on 1/9 of 2024. She went to Sunoco. She paid $100 to a Black female who had her iPhone 10. That phone did subsequently break. She took it and had it repaired or replaced at the iPhone store at Briarwood. She said when she did report on the 10th, per the report, Judge, she indicated to Community Corrections that she did have a marijuana cookie, 2 marijuana cookies. And so she indicated that she didn't know she was going to be positive. And that's when she said, what do I do when my test comes back positive? However, that apparently did not metabolize in her system at the point of that test, but she thought that first test would have been positive, Judge.
Okay, so the cookies now appeared on the 10th.
Yes, Judge. It happened the day before her reporting, Judge. So I guess that would have been the 9th, reported on the 10th.
Go ahead.
Okay. She indicated since that time, she has in fact been using marijuana, and that is why she has failed to make her testing dates, Judge. She indicates that she knew she was going to be positive on the 10th from the cookie, and she knew that subsequently she'd be positive from actual smoking of marijuana. So she missed those tests until she actually went in on 124 and tested and did have that positive result. She indicated that her last time smoking would have been 2 days ago on Tuesday, the 27th, Judge. She indicates that she does not have an addiction and that she can stop smoking, but that she had not stopped at this point, and that she takes responsibility. She apologizes. She sees how serious this is, and she wants
Hold on a moment. I need to go back to the 9th.
Okay.
You had the cookie when?
It would have been the day, either the 8th or the 9th. The party would have been, she believes it was the Friday, January the 9th, I believe that date was, she indicated, at her friend's party. Obviously,
When did she get out of jail?
she got out on or about 12:30. Because community correction received this order for her testing on December 30th.
On December 3rd?
Yes, Judge.
December 30th.
It says new order received on 12/30/2023.
Right.
So that's when she would have been released, I assume, Judge.
And she doesn't report until the 9th or the
She-
10th.
Correct, Judge.
Why is she late reporting?
Well, she didn't call initially, Judge.
Why?
She apparently didn't want to, Judge. Then she lost her phone on or about January 7th. Just trying to be honest with you, Judge, that's what happened. Okay? On the 7th, she lost her phone. She recovered it on the 9th. She had that cookie. And then she reported on the 10th, Judge. Since that time, like I indicated, she has been smoking marijuana due to the stress of the situation. She's not denying that. And that's why she has failed to make subsequent reports aside from that January.
So she just decided that she just was going to do it her way.
She did, Judge. She did. And she's not denying that, Judge.
Not now.
But obviously, I've impressed upon her.
So why did she go over the data test?
My understanding, she spoke to Ms. Gaines, and Ms. Gaines told her she had some prior failures to report, and that she knew she had to go report. So she went today. So she's tried to actually comply, and I told her now how serious this is. I don't know if that was impressed upon.
So she just started taking marijuana without a card in violation of the order on the 8th, 9th of January.
That's the cookie, right? Subsequent to that, she started smoking.
So before that, what?
Before that, she indicated she didn't use often. Not never, but not often. But now she's been using pretty much 3 days a week. At that time.
And she knows she's not supposed to.
She does, Judge. You understand? Something that she's not denying now. She was scared, and obviously she has 2 small children. She has a full-time job. She didn't want to lose her job, didn't want to have difficulty with her children. Understands now, she just can't do it. She doesn't have a medical marijuana card. She has no excuse, and she knows that Your Honor's not playing about marijuana, not playing about following court orders. And she indicates that she is given the
Well,
opportunity.
it's a court, and I'll tell you, it's the court gave her an order.
Yes, Judge.
And she decides that she just wants to not follow the court's order.
Yes, Judge.
Then she gets here, gets called on it when she was up here initially, and then it's just through you just lying to me.
Yes, Judge.
I apologize, Your Honor.
You don't lie to the court, ma'am. You just don't. I'll deal with the truth. We can work that out. But if you're going to sit here and lie to me, then that's going to be a problem and you're going to pay a consequence for that.
That's what I told her in the box, Judge. When I sat down with her, I told her that she has to be straight with you. The truth, you generally work with people. Okay, that she apologized and she's sorry that she wanted me to tell you what was going on, how she got to this point. She said she's had difficulty dealing with the stress of the situation. She's looking forward to getting this resolved. The prosecutor did make her a very reasonable offer. We're just trying to get proof of that payment for the destruction of the broken window to try to get these pled out. But obviously, she needs some help. She's not afraid to go to treatment if the court thinks she needs treatment, but she believes she can quit. And in 30 days from Tuesday's date, this should be all out of her system completely, because Tuesday was the last time she would have used, Your Honor. But she did, the 27th.
She just kept doing it.
Yes, Judge.
That's the problem. And the problem is, had she left here today, she would just continue doing it and continue violating this court's order.
Yes, Judge.
And quite frankly, her promise doesn't mean anything to me.
Understood.
It just doesn't. Had she taken the test, say, this is why I'm doing it.
At this point, the entire direction of the case has changed. This is no longer just about missed drug tests or marijuana use. It's about credibility. In virtually every American courtroom, especially during pretrial release or bond supervision, judges expect strict compliance with court-ordered conditions. Missing tests is typically treated the same as failing them because the court cannot verify compliance. But what really caught the judge's attention here was the repeated inconsistency in Julie's explanations. Once a judge believes a defendant is being less than truthful, every future statement is viewed with greater skepticism. Defense counsel did the right thing by pausing the hearing, reviewing the violation report, and encouraging complete honesty, but rebuilding credibility in court is extremely difficult once it's lost. What do you think? Should the judge focus more on the admitted marijuana use, or was the dishonesty the much bigger problem?
Failed the test, that's one thing. But she just decides that she doesn't have to take the test, takes the test, then decides she doesn't have to want to take the test, just continues using.
Yes, Judge.
So violating the court's order in two ways, first by her use and then also by not going to testing. And then all on top of that comes here and lies to me. Anything else you want to say?
To her credit, she did eventually come forth and tell Your Honor the truth. She's came clean with me about what's going on and how we got in this situation. She acknowledges that she might have a problem because managing her stress, she's been unable to not use marijuana. And so she acknowledges that and is willing and ready to seek treatment, Your Honor.
Your screen is locked on your phone. How is somebody else using your phone?
My screen. They can answer calls still.
Can they call out? No, and they did. So I don't believe the phone thing either, even now, as you're saying. Adjourned to March 7th, this week, 2024 at 9 a.m. And lady, you're gonna have to figure out how you want to do this. You're here on a DV charge or DV type charge. You got resisting and obstructing. You're not following the court's rules. Has her 9mm handgun been surrendered?
Yes.
Yes, Judge. And she indicates that the window has been paid for, that was broken in the incident.
You got to follow the rules. And the most important thing is you don't lie to me.
Understood, Judge.
Defendant's bond is revoked pending a hearing on March 7th. Defendant's remanded.
Thank you, Judge.
Court calls the case, People versus, well, not yet. See you there? Julie Vancapon.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
Alex Warren Green on behalf of Ms. Bonkachan. Please state your name.
Julie Vapachan.
Your Honor, this time we're asking the court to set the matter for a preliminary examination. If I may address bond.
Sure.
Thank you, Your Honor. Ms. Bonkachan was last before the court a week ago. That time she was remanded for bond violations. I believe she had 2 missed tests and a positive test.
That and lying.
Of course, Your Honor,
Okay.
and that's
Okay, go ahead.
Ms. Bonkachan does wish to apologize to the court today for being dishonest at that time. She's assured me that she will continue testing, that she knows what she needs to do, that if her phone wasn't working or anything else like that, that's really not an excuse to miss testing. She's fully employed at the University of Michigan Hospital. Sorry, Your Honor. And cares for her 2 children. Right now, her 2 children are living with her sister. So we're just asking the court to consider reducing her bond. Right now, she's held without bond or a personal bond.
I'm sorry.
Go ahead.
If her children are living with her sister, then I'm really concerned because I do have note that she called the victim 41 times. And my understanding was the only reason to
Excuse me?
contact the victim was to have contact with the children. So if the children are not with the victim, then I am concerned.
Okay, hold on. So the Daniel Gray, I have listed as the victim.
Correct.
Found the street.
There is contact allowing for conversations about the children. That was my understanding of the bond conditions. So if the children are with her sister, I see no reason for her to have contact with the victim.
Well, the conditions that I have is that the only communication that would have been allowed with the victim regarding the children would have been by text.
There have been 41 phone calls.
Your Honor, that's the first I've heard of her making any phone calls from the jail. My understanding is that the children are living with Ms. Bonkachan's sister and that they do spend time with their dad, who's the complaining witness in this case as well. And prior to her incarceration, it sounds like she did have contact with her dad for purposes of raising the
With
children.
who?
With the
Mr. Gray.
children's dad, the complaining witness in this matter.
Right.
Yeah.
That's 41 calls this week?
41 calls since she's been taken into custody. That
Oh, dear God.
Some conversations, we never argued or anything, it was just straight about the kids.
Counsel,
Well, Your Honor, that's the first I've heard of it. I don't think
do
this
you
one.
want to talk to her about it? Because, I mean, here's the problem. Problem is her bond conditions are that she could only communicate with that individual by text. I realize being in custody, that may not be able to happen. But then the only communication that can occur via text is it has to be regarding the children. Got 41 calls to this person. I have 41 calls to this person and then find out that the person that would be caring for the children is not this person, is not the victim. That's a problem. Just on the face of it, it's a problem.
I understand that, Your Honor, and I know Ms. Fonfachan's primary.
I hate to do
concern
this
is
to the
for
sheriff's
children.
department. Why don't, because theoretically, she may have been released. But this throws a whole new light on everything because she hasn't been doing I mean, she's just making her own rules, which is really part of the problem with how she got herself in, outside of lying to me. And now, and not following her bond conditions. And then now I got another one, potential. So let me do this. The sheriff's office would be so kind. Take her back. You might want to talk to her because otherwise. And he's not coming out.
No.
No. Who? Okay, but Seal's not coming out. Court does call the case of People versus Marshall Seal.
Andrew Childers appearing on behalf of the people.
Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Seal. Your Honor, I believe that
Mr. Seal refuses to come out, so I can't do anything.
Your Honor, I understand he has a very busy social schedule in the jail.
Sure.
He wanted to squeeze you in. If we adjourn this, I'm sure he can clear his schedule.
Okay, that's what I'll do. I'll adjourn it.
Just for the record, the first clock isn't started.
Correct. He needs to be here before I can do anything.
Right.
So probable cause, March 28th, 2024, 9 a.m.
Thank you, Your Honor.
On continued.
I'll speak to the social secretary right.
You do that. Case People versus Microphone.
Assistant Prosecuting Attorney Morgan Barroso, on behalf of the people.
And Alex Warren Green on behalf of Ms. Fonfachan. State your name again.
Julie Bompachan.
Thank you. Your Honor, I had an opportunity to speak with Ms. Fonfachan. I addressed the phone calls with her. And, Ms. Fonfachan doesn't deny calling the complaining witness in this matter. I don't know the subject matter of those calls, but what Ms. Fonfachan tells me is that that subject matter, when those calls are reviewed, is going to come back largely regarding the children, and that the discussions they were having were about the children. The children are staying with her sister while the complaining witness is working. That is filling the void left by Ms. Fonfachan being in custody. Before Ms. Fonfachan was in custody, the children would stay with her while the complaining witness worked, and when he wasn't working, would stay with him. So that arrangement is the same. It's just that Ms. Fonfachan's sister is taking care of the children while the complaining witness is at work. So again, I don't know the subject matter of those calls. What Ms. Fonfachan
Okay, so- And you don't know from the people, you don't know the subject matter of the call.
Your Honor, when I saw 41 calls, I was under the impression that they would be related to the children, but that doesn't eliminate my concern.
I know.
And I'm also concerned at her representation that is largely related to the children, which to me leaves room for an understanding that there's other things being discussed as well.
And Your Honor, what Ms. Fonfachan tells me is that none of their communications regard the case. None of them
Okay.
are communications regarding what the complaining witness should do or can do or may do. It's nothing to do with that.
Okay, I get that. But all that does is stop additional charges. Right?
Of course.
Or that goes to whether or not there would be additional charges coming from the prosecutor's office. They don't go to what is another violation of the court's order. I mean, just the call itself. I mean, I could even understand if there were a few calls regarding the kids because she can't text because of the position that I can get that. 41?
It's a large number of calls, Your Honor. I understand the question.
And here's my other problem. And this is the problem that people have when they come before me and they lie. You lie to me, then it's hard for me to believe anything that you're saying. And so if you're saying you're calling regarding the children, are there calls to her sister at least?
I have not checked. We don't have the sister's phone number because
Got
it's
it.
not in the police report.
Counsel, how soon can you get the phone calls to?
I'll send an email request right now.
Pardon?
I will send the email request right now. Usually they get released within a day.
Well, during the probable cause out 1 week. Or is that what we were doing on this? Yeah. Oh. Dear God. I'll adjourn our probable cause out 1 week to the 14th. 9 a.m. Get the calls over. At this point, I'm not going to set it for exam. At this point, what I'm going to do is then let's do it this way. You wanted it set for exam, correct?
That is correct, Your Honor.
All right. I'm going to give you a probable cause date on the 14th to try to address her bond to see if we can get her out of custody without some other thing happening. I'll set her preliminary examination. I'll set that for the 26th, 2024, 9 a.m. That will be before me. Next week, though, we'll address her bond after you've had a chance to listen to the calls. And right now, she has no way to communicate about her kids at all because she was doing it by text before.
That's right, Your Honor.
And at least pending the hearing next week, her phone privileges, defendant's phone privileges in their entirety are revoked. Just keep making it worse. Continue. Thank you.
This hearing is a perfect example of how courtroom outcomes often depend on much more than the original criminal charge. Julie's situation escalated because the court believed she repeatedly violated bond conditions, skipped mandatory testing, admitted continued marijuana use without authorization, and most importantly, failed to be truthful when questioned. Even after later admitting what happened, the judge emphasized that honesty from the very beginning is what allows a court to consider leniency. The additional concerns about repeated phone calls to the alleged victim only reinforced the court's belief that supervision conditions were not being taken seriously, resulting in her bond remaining revoked and even her phone privileges being suspended pending further review. The case itself is still moving forward, but this hearing shows how quickly bond violations can change a defendant's position before trial. If you found this courtroom breakdown informative, don't forget to like the video, share your opinion in the comments, and subscribe to the channel for more real courtroom cases, legal analysis, and dramatic hearings you won't want to miss.